Good day everyone, especially to our teacher, Mr. Melvin Libuno. In today's video, I will discuss to you the intellectual property rights policy. So let's start for the introduction of intellectual property laws. So, for you, what is intellectual property? What do you think when you hear the word intellectual property? Can an idea or invention that exists in your mind be considered property? Yes, it can. Intellectual property is an invention or an idea that gives a person the exclusive rights to a product or a process. There are many types of intellectual properties like inventions, discoveries, artwork, and writings. Intellectual property can be stolen. Someone can misuse it without permission. Violation of intellectual property rights, also called infringements, that can result in a lawsuit or a fine depending on the type of intellectual property involved. Intellectual property is protected by copyright laws, patents, and trademarks. There are steps that can be taken to protect one's property. Intellectual property's value is not based on physical properties. Instead, intellectual property is valuable because it holds ownership and exclusive rights to use, sell, and promote a creation or idea. Intellectual property law protects the results of human creative endeavor. Intellectual property is generally thought to comprise three separate fields of law, which is the trademarks, copyrights, and patents. It is important that one should understand the IP rights which may exist in the context of his or her business and are vigilant in their own safety and protection. Each type of intellectual property has different protection requirements, which give different rights and different protection. So here we are in our main topic, which is the intellectual property. When we say intellectual property, it is the intellectual work which is produced by the intellect of human brain, the creations of minds such as invention, literary, and artistic works, designs, and symbols, names, and images used in commerce or business. It deals with laws to protect and enforce rights of the creators and owners. So, for example, you have created a brand name, or I should say logo for itself, which is for your business. All of that is the creation of your imagination and creativity of you, a person, or a group, and it is considered as intellectual property. The Republic Act number 8293, it explains that Intellectual Property Code of the Philippines is made to protect and secure the exclusive rights of the scientists and mentors, artists, and other gifted citizens to their intellectual property and creation. Moreover, we have three types of intellectual property, such as patent, trademark, and copyright. Next, what is meant by patent? A patent is a grant from the U.S. government that permits its owner to exclude others from making, selling, using, or importing an invention. The example of patents are commonly the products of every company for the goods of the people that make them provided and consumed by the consumer as well. The other reason why product is the common thing that used in the patent because the products have an owner and they legalize it to include form, making, or selling as well by limited period of time. The example of patent products are the design for a water fountain and design for shoes, Converse All-Star sneakers. So, we have two types of patent invention. First, the patentable invention. Second, the non-patentable inventions. When we say patentable inventions, it is any technical solution of a problem in any field of human activity which is new, that involves an inventive step and is industrial applicable shall be patentable. It's related by the following: the product, process, or improving any foregoing. Patentable invention, these are the products that we need to improve and manage legally as well. While the non-patentable inventions, it is the following that shall excluded from patent protections, which are discoveries of scientific and mathematical methods, methods and treatments, plant variant and breeding animals, contrary to public or morality. So, non-patentable inventions, these are the products that are not functioning. So next, what is meant by trademark? A trademark is a word, name, symbol, or device used to identify and distinguish one's goods or services and to indicate their source. So, trademark is a word or accommodation of words, letters, and numerals can perfectly constitute a trademarks. But trademarks also consist of drawings, symbols, and three-dimensional features like shapes, packaging of goods, then visible signs like sounds, fragrances, color shades, used as distinguishing features at the national or regional levels. Trademark protection can be obtained through registrations by filing an application for registration with the National or Regional Trademark Office and paying for its required fees. In the international level, you have two options. Either you can fill a trademark applications with the trademark office of each country and which you are seeking protections, or you can use the World Intellectual Property Organization and principles. Trademark registrations confer on exclusive rights to the use of registered trademarks. So, this implies that the trademarks can be exclusively used by its owner or licensed to another party for using return payment. Trademark rights are private rights that can be enforced through courts. The term of trademark registrations can vary, but it's usually 10 years, so it can be renewed indefinitely on payment for additional fees. The Nike shoes, the golden arches of McDonald's, the Apple logo are some examples of trademarks. So now, we have three types of trademarks. First is the service mark. Second, the design marks. The third, certification mark. So, let us talk first about service mark. It is the same as trademarks except it identifies and distinguishes the source of services rather than goods. When we say design marks, it is protect your logos or your styling asset. The third one is the certification marks. The certification mark is very different from the company's logo and trademarks because it is the guarantee to consumers that the products has undergone. So, all of this is generally referred to the main head called trademark. Another example is when Apple created an iPhone, so it is registered as patent for the phone itself. So the trademark is the iPhone for its brand name. Next is the copyright. When we say copyright, a copyright protects original works of authorship, including literary, musical, dramatic, artistic, and other works. So, the copyright is the intellectual property that governs or protects from the creation of minds such as the inventions, literary, and artistics that includes computer programs. The copyright is automatically works when the form is in a tangible form. So, it means if the form is not in a tangible form, the copyright will not apply because the copyright does not apply to ideas that have not been recorded, work that have not been written. So the copyright, it only applies in a tangible form. When we say tangible form, it must be a visual or being created by an author and being published. The copyright law is also helps to protect the author's creation or the work from the other people that are trying to copy or plagiarize their work without permission, because if the individual just copy and publish the work without permission to the owner, so probably an individual or other creator could violate the law, which is the copyright. So that's how copyright works, that covered by the copyright with the books, newspapers, musical composition, choreographic works, dramatic works, articles are all examples of fixed form or tangible form that are not being created by an author or published in the copyright protection. There are two types of rights under copyrights, which are the economic rights and the moral rights. Under economic rights, we have public display right, which is a right to display or show the work in public. So like for example, you're watching a TV show, so the author of it or the creator of it given the right to display it in public or display in a television. In economic rights, we have also the distribution right. The distribution right is the right to distribute the copies of the work in public. For example, copies of a book are being distributed in a public, so the author or creator of the book can sell it as well as earn money because an author had given the right. We have also the public performance right. So the public performance right is the right to recite or up in public, like for example singing in the public or other work that performing in public. So those are all covered by copyright. The reproduction right, it is the right to copy a work or duplicate a work in a fixed form or in a tangible form. For example, an author is photocopying a book, so the author have given right to copy or duplicate or make their own copies. But modification right is to modify the work to create a new work based on a free existing work. Modification right, also known as derivative work. So when we say modify, it means to improve or to arrange the work that already existed. So let's say for example created a new music composition. So in that music there will be an improvement and arrangement. So that's we call modification right. While in moral rights are the personal rights that connect the creator of a work to their work. Under moral rights, we have right of attribution, which requires that your name is always shown with your work. So like for example, if you will publish a work or a film, so your name should always appear next to your work. The limitations in copyright. Fair use is an act of copying of copyrighted materials for purposes such as commenting, criticizing a copyrighted work without the permission to owner. So, fair use, it is used as a defense under copyright infringement. So, when we say copyright infringement, it is the use of copyright protected work without the permission of the copyright. So, let me give you an example of violating copyright. A content creator is downloading a music or a movie without paying for their use. Another example, copying any literary works without an agreement with the owner or in author. So that's the end of my presentation for today. I hope you learned from the topic. Thank you.